companies are the most popular form of business organization. This course deals with the life cycle of a company, from birth to death, and all that happens in between. So, what exactly does company law cover? Company law covers the way in which companies are different from other types of business structures, such as sole traders, partnerships, joint ventures, and trusts. The course highlights features unique to companies, such as limited liability and perpetual succession, which means the ability for companies to live forever. So, what then is a company? It's an artificial person created by law. The law allows us to pretend that a lifeless bunch of papers sitting on a shelf is, in law, a separate legal person with its own life, own rights, and own liabilities. These are powerful features which makes companies very attractive to use as a business structure. Because a company is a separate person, it can hold property in its own name, it can contract in its own name, it can be sued in its own name, and its liabilities are its own and not those of its members or officers. This separation is known as the corporate veil. Ordinarily, the law will not look into the company to see who is in charge or control unless legal grounds exist to ignore or pierce the corporate veil. Such grounds exist under both common law and the Corporations Act. For example, Section 588G of the Corporations Act imposes personal liability on company directors for company debts during insolvent trading. Parliament has elected to lift the corporate veil here to make directors accountable for financial management and to protect creditor interests. There are 8 key aspects that are covered by company law. First, company law covers the way in which the law provides for different types of companies. Companies come in all shapes and sizes, ranging from a single-person proprietary company, that is, with one director and member, to small and large proprietary companies, to public companies which often extend into corporate groups trading across many countries. In contrast to proprietary companies, public companies have at least 3 directors, a company secretary, unlimited membership, and the ability to raise funds from the public via a disclosure document, such as a prospectus. All companies across this range, from big to small, are included under company law. Second, company law covers the way in which companies are created. Companies must comply with many formalities under the Corporations Act to set up a company, which includes the payment of registration fees to the Australian Securities and Investments Commission, that is, ASIC, the corporate regulator and watchdog, with oversight and law enforcement functions over all companies in Australia. A company is born when it gets a certificate of registration from ASIC. The company attains instant maturity, and Section 124 of the Corporations Act gives the company all the powers of a natural person. That is, a company can more or less do anything that individuals can do, such as enter into contracts and hold property. Third, company law covers the way in which a company makes decisions. This can be done either via a meeting of the board of directors or via the meeting of the company members. Members are not allowed to exercise management powers unless authorized by the company's constitution. Members dissatisfied with the decisions of a director in a public company can exercise their statutory right to remove the director, or they may choose not to vote to re-elect the director at the annual general meeting. Fourth, company law covers the way in which a company is held accountable for civil and criminal wrongs. The law's treatment of a company as a fictitious person brings with it many challenges. For example, how is a company held accountable and liable for contract, crime, and tort? A company must act by human hands in the real world. This raises practical questions such as whose acts are to be regarded as the actions of the company? Fifth, company law covers the way in which a company is managed. Every company must have directors who are collectively referred to as a board. The company's constitution typically gives directors the exclusive power to control the management of the company's business. Because directors are in a very powerful position to influence the company's decisions and affairs, they are subject to strict fiduciary and statutory duties. For example, directors are prohibited from having any conflicts of interest, such as making personal profits or taking up corporate opportunities without making full and proper disclosure and obtaining the genuine consent of the company's members. Directors also owe the company a duty of care and diligence. This means that directors must pay attention to the company's affairs, including its financial affairs. It also means that the law will not tolerate passive or ignorant directors who fail to seek out company information that is either available or which they can demand. If they breach this duty, directors can be banned and fined hundreds of thousands of dollars by the court. And for some offenses, the fine can be in the millions. Sixth, company law covers the way in which a company raises finance, including equity finance, such as shares, and debt finance, such as debentures. Chapter 6D of the Corporations Act sets out the rules for corporate fundraising when a company issues such securities. These rules aim to allow investors to make an informed investment decision based on accurate and reliable information, which must draw attention to both the potential benefits and potential risks attached to the securities on offer. Seventh, company law covers the way in which members can exercise their rights and be protected from unfair treatment at the hands of the directors or majority members who may abuse their voting power. For example, by seeking to expropriate shares of other members in an unfair manner. The Corporations Act sets out remedies for conduct against members that is oppressive or unfairly prejudicial or unfairly discriminatory. And eighth and finally, company law covers the way in which a company can deal with financial distress, such as corporate rescue, either via a scheme of arrangement or via voluntary administration or via receivership. The main aim of voluntary administration is to maximize the chance of corporate survival. But if that's not possible, then the alternate aim is to get a better return for creditors than an immediate liquidation. Not all companies, however, are capable of rescue, in which case it is appropriate to liquidate or wind up the company. Liquidation results in the closure of the business and often leads to the death of the company via deregistration. The dramatic powers conferred by the law onto companies is further illustrated by the fact that companies may be brought back to life and reinstated in limited circumstances via a court application. I hope you have enjoyed this brief insight and a journey through the life cycle of a company from birth to its death and possible reinsurrection.